Welcome to today's program titled COVID-19 Immigration Compliance I-9 Update. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Angelo Paparelli. Go ahead, Angelo.
Thank you, ladies and gentlemen. It's a pleasure to be here, and we hope at Seyfarth Shaw to provide you with useful, actionable information on I-9 compliance and E-Verify compliance in these challenging times of pandemic. I'm going to offer a very quick overview of the sequence of events in terms of governmental announcements. Let me begin by saying that on March 20th of 2020, we received from Immigration and Customs Enforcement, ICE, a new procedure for allowing virtual I-9 completion for a temporary period of remote hires only, not for those who would be otherwise expected to appear at company headquarters. That was initially to expire on May 19th, tomorrow, but it has been extended for an additional 30 days as of an announcement on May 14th. Also on March 20th, the ICE agency announced that any notices of inspection for I-9 compliance that employers may have received in the month of March will be given an additional 60 days to respond. Again, on May 14th, ICE likewise extended that benefit for an additional 30 days. On April 3rd, USCIS issued Q&As for I-9 compliance and E-Verify compliance that you might find helpful, but we'll be discussing. And then on May 1, the USCIS E-Verify team issued a temporary policy on List B documents of identity to be used for I-9 compliance during the COVID pandemic. With that, I want to say that everything that you'll hear is not to be considered legal advice. This is something that will be of general nature, but you're always welcome to reach out to us if you have specific fact patterns and particular questions. Let me introduce our speakers today. We have quite a crew. Dawn Lurie is a well-known authority on I-9, E-Verify compliance, and employer defense in enforcement proceedings under the immigration laws. She's active in bar association liaison activities with numerous federal government agencies in this space, and she's a noted published authority. Leon Rodriguez is the former director of USCIS under the administration of President Obama. He's also a former federal prosecutor. He is a partner in our immigration compliance team and in the firm generally, and a respected, noted authority. My colleague in Los Angeles, Masa Aliascari, is an experienced immigration lawyer with coming on 2 decades of experience in this field, and her practice covers immigration compliance as well as immigration benefits. And Randall Johnson is the past vice president of the U.S. Chamber of Commerce for labor and employment, including immigration matters, and is a member of the firm's government policy team, as is Leon and myself. I practice immigration law and have been doing so for 40 plus years out of Los Angeles and have a background in immigration compliance. With that, I want to turn it over to Randy and ask to give us a COVID-19 compliance update.
Yeah, well, Angelo, let's go to the policy material, I think, first, and then maybe we can. Whenever I talk about immigration policy, I feel like Sisyphus rolling the rock up the hill, and we seem to one step forward, two steps back. Many of you recall back on April 22nd, the president issued a proclamation limiting, he thought it was going to be much worse than it was, but limiting immigrant travel. Turned out to be fairly, with regard to certainly non-immigrants and temporary work visas, it really wasn't that much of an adverse hit, certainly on the business community. But part of that was to include a mandatory study of the impact of non-immigrants and temporary work visas on U.S. workers. And the administration has charged the Department of State, Department of Labor, and DHS in putting together this so-called study. Now, we've all seen many studies on immigration, and the vast majority conclude that they are beneficial, of course, to the United States economy. But that all being said, we do not have an administration that's receptive to immigration generally, as we well know, and we're hearing many kinds of rumors floating around. I think the three top ones we're hearing about that raise the most alarm are the three identified on this screen, which is a blanket ban on new H-2B non-immigrants in the U.S. unless they're essentially part of the U.S. food supply chain. And you'll notice that H-2A is not on this list for obvious reasons. But the H-1B program has long been the target of some at the White House, and a blanket ban on new H-1B non-immigrants entering the U.S. unless the beneficiary is being paid at wage level 4 for the job in the area of intended employment. Now, the level 4 argument has been a oldie but goodie floating around for at least 2 years now, and certainly some view that the wage level, which is now about $130,000, as a proxy for best and the brightest. So if the employer community is defending the H-1B program as the best and the brightest, well, why can't they pay a level 4 wage? As many of you know on the phone, that would be impossible for a lot of actors in this area, although there's a lot of studies out there that certainly criticize the lower level, the ones and twos, as being inadequate to protect American workers. I raise that just to say I think this is a tough argument, and it's not a new one, and we're going to have to face it. And then the last one is a blanket ban on new L non-immigrants. This, again, is sort of new, but it's old in the sense that sort of opponents to immigration have argued often that the employer community was using the L visa category, which is uncapped, of course, to get around the H-1B visa cap. And I think we're going to see those arguments again. So, again, these are still rumors, but they're fairly well-founded. It's a matter of concern to us. We at Seyfarth are working with some of our clients to pull together good examples of the benefits of L's and H's to the U.S. economy and to American workers, and are working with the BRT and the Chamber to help push back on some of these ill-thought ideas. Now, the Pelosi bill, which recently passed the House, 1,800 pages of it, had a lot of things in it, but buried in there were some, I think, good immigration provisions, frankly, from the standpoint of the business community. They probably likely won't see the light of day in the Senate, and in fact, they were part of a motion to recommit by the Republicans, which gives you some idea of the politics surrounding immigration these days. But Angelo, I know you were looking at those. Do you want to briefly comment on what was in the Pelosi bill?
Yes, that is House Bill 6800, which passed last week, and in Title 12, there was one section that created relevance for this audience in that it granted automatic extensions of employment authorization for a period of 1 year from the date of enactment or the date 90 days after the COVID pandemic is declared to have been under control. The likelihood is that this bill will not pass, 6800 will not pass, but it opens up the discussion about the need for immigration responsiveness so that employers can continue to retain workers who are here and who are unable to leave in any event. With that, I think we can move on to the body of our presentation, and I'm going to turn it over to Dawn.
Thanks, Angela.
Thank you so much, everyone. All right, so today we are going to be talking about I-9 compliance. We decided that we're going to pull the M274. We were going to touch on that. We're going to do a separate webinar on the M274. If any of you have questions, you can certainly send those in after this. The one thing that I do want to mention, the M274 is the new employer handbook. It's kind of companion to the I-9. It was just recently released. If you haven't seen it, you want to go ahead and pull it if your job entails doing I-9s. One of the things that we heard from our clients in terms of feedback, and I know it's a big issue for our group, are the instructions on CAP-GAP for individuals that have H-1B employees or individuals that petitions were filed, students that were on F-1 visas that are moving to H-1B visas. There's a provision in the M274 that the USCIS would like employers to record 797 receipts. And for those of you that live and breathe immigration, you know that receipts are taking an awfully long time to get. So I just wanted to let everyone know that it's on our radar. We have been discussing it with the agencies, and hopefully we'll have some new information on that soon enough. Okay, so with that, we're going to move on to talk about Form I-9s and the flexibility. As Angela had mentioned, things have changed due to the unprecedented time that we're living in and the pandemic and the differences in the way individuals are being hired and workplaces are going about their daily business. So just to kind of remind everyone, when you have a Form I-9, Section 1 is completed by the employee and Section 2 has to be completed by the employer. Normally, Section 2 has to be completed by, well, not normally, always, Section 2 has to be completed by the third day of work for pay. We call it the Thursday rule. And basically, if you're hired on a Monday, you have to complete Section 2 by Thursday. So keep in mind that the timelines are still in play. Anything we're talking about today has not changed any of the timelines. The employee always has their choice of documents in which to present. And generally, they would be bringing them into you and you would be physically inspecting them. The government has decided that a physical inspection includes in-person inspection. So that's how they've for as long as I can remember, they've interpreted the regulation to mandate that this physical in-person inspection. So what's happening now is employers are not in a position. Some employers were needed to, if I could just ask, I don't know who's ever not on mute, if we could mute, a lot of background noise. I don't know if anyone else is hearing that. I apologize. So what had happened was as soon as we realized that employers were not going to be able to continue to conduct I-9 inspections, we went to the government and we asked them, hey, how are we going to take care of this? We thought it was going to be a great opportunity to kind of push the agenda forward on allowing for a total relaxation of the in-person requirement, which again, I'm going to keep on saying I'm not even sure that it's regulatory. And it took a little bit of back and forth between the agencies, and a lot of different organizations were involved in pushing this. But ICE came back and said, okay, we are going to allow for some flexibility. Okay, and the flexibility that they ended up giving us allows for companies that are not working in person, in other words, for the employees are not on site, to defer the physical presence requirement and allow for the I-9s to be completed virtually. We'll call it virtually, remotely. I'm going to refer to the flexibility requirement, but basically they've allowed for individuals to be able to conduct their business in a way that we've never been able to do that before. So the other thing that we got in the first announcement was a relaxation of the responses that were due for notices of inspection. So one notice of inspection, for those of you that are familiar, it's when the government knocks on your door, when when ICE comes in and says, "Hey, we're going to inspect your I-9s," and they'll issue you a notice. What we were seeing that first week of March, when we were already well into COVID-19, we were seeing ICE delivering another round of notices. Frankly, when I first started hearing about it, I was very surprised. I did not think that the government would continue to issue these notices when most people were at that point already staying home from work or starting to consider staying home from work. I think it was like the first 2 weeks. We had the opportunity to speak to some agents that were coming into some of our clients' locations, and they were saying, "Hey, we're just following instructions." So what happened was, when this guidance came out on the 20th, the agents were also told that they should not be serving any additional notices. So to be clear, what that means is, if you were served a notice, you don't have to respond to it right away. It'll follow the timeline of the flexibility. Now, what the agents were told, though, is you have a lot of backlog. Go back, and the agents and the auditors should go ahead and work that backlog. All right. And that's what they have been doing. So you will see, if you have an open audit, you will see that individuals are, individual ICE offices are still moving, and you may get notices and updates from your audit. Now, they never said specifically, there's a moratorium on ICE worksite actions or notices of inspection. That was never said directly. However, from our relationship in the agency, we understand that they're not serving, general administrative NOIs, if that's what everyone is asking. I see some questions coming in on that. I would guarantee you, if there was a criminal enforcement action that needed to take place, that it would still take place if there wasn't, individuals that were working on site, if it had to. So I think I have no idea, but that's just my intuition. All right, so they're cleaning up their backlog. So what do we have now for I-9s? We have 3 ways that we can complete I-9s. 3 ways are the virtual remote, and that's what we just started to talk about, right? So that's the flexibility where you do not have to do the I-9 in person. And then we also have the authorized representative, which is during COVID. It's an option. It's always an option, and we'll talk about it. During COVID, we're seeing the authorized representatives being people that you're sheltering in place with. So we're calling it the friends and family option. Then we also see the regular, normal, in-person I-9, where people are coming in, they're being hired, and they are working. They're working and they're having their I-9s done. There's a lot of challenges now for HR directors. Those of you that are in that shop or in that organization, within a company, or even in legal, you're dealing with a lot of concerns. We have HR managers that are saying, look, I'm going to go in. I understand that I need to be there for X, Y, and Z, but I'm not conducting routine I-9s. I'm not onboarding people. I don't want people in my office. I don't want to touch their documents. I don't want them to take down their masks so that I can look at their face to sign an attestation that says that I've identified them, that I've matched their identity. I don't want to do that, and I can't identify them with a mask on. So what am I going to do? Suffice it to say that we've had an ongoing dialogue with the folks over at the two agencies, at the USCIS, as well as Immigration and Customs Enforcement. So this is something ongoing. They are well aware of our concerns, the concerns of HR, and I'm hoping that we'll continue to see questions and answers, and some of which we'll talk about today, coming out from the agencies. It's a trying time. I'll keep saying there is no normal. The new normal, we don't know what it is, but it is important to get feedback. And what we've explained, and I think taking a step back on the virtual, frankly speaking, I was really disappointed, because when we saw the virtual, we asked for the virtual, but it wasn't what we asked for. We were asking on behalf of companies that were still in hiring mode. In fact, some of them were having hiring surges, right? Certain industries needed to ramp up in order to continue to serve the public. They were, in essential jobs, whatever it was. So it could be, grocery, it could have been online, healthcare in particular, right? We had, certain hospitals that were, bringing people back in as if the Form I-9 was something that they, needed to worry about. But what the government said was, if you have people there, even if you don't have your HR staff, you still need to complete the I-9. So that was frustrating. It was not what we wanted, but it's, it is what we got. So for the virtual option, again, the government was very specific to say it's where where your shop is closed up. I think, and I'm willing to go to bat for employers. If you have a security guard or maybe a tech person that's coming in, I still think you're operating remotely. If your offices are closed and you don't have people going in, you're operating remotely. There may be situations where the office is closed and people may be choosing to go in. You're still operating remotely. It's going to be very important to document, to maintain that written documentation of what your remote onboarding and what the work policy is, the remote policy is for the organization, as well as for any employees that may have differences in the day-to-day. So if you use that remote option, it's going to be, you can do it via video, FaceTime, GoTo, Chime, Google Meets, anything like that. The government policy says if you do work virtually or remotely, you have to make copies. Okay, so it doesn't matter whether or not and what I mean by copies is copies of the identity documents. Okay, so the identity and the work authorization documents. And you'll have to maintain them. Someone called me last week and said that they were listening to some sort of webinar that the USCIS or somebody affiliated with USCIS had given, and they had said that you didn't have to maintain the copies after you re-verified in person. I haven't seen anything like that. I think it's a really bad idea. Got a couple questions on that over the weekend, starting last week. The regulations say once you take copies, they're part of the record. I do not recommend that you destroy anything. So, it's not a big deal to maintain an extra document. If you're electronic, you've already uploaded it into your system anyway. So just kind of wanted to throw that out there. Yep.
Question on that. I have a lot of clients who tell me, well, my folks don't have printers at home or scanners or fax machines, and I am HR. I'm working from home, and I don't have a printer. So when you ask me to make a copy and attach it to my I-9, well, we're not working physically with anything. What am I supposed to do in that respect? Can I take a screenshot if I'm talking to someone on FaceTime or Zoom? Can I take a screenshot of that and save it somewhere?
Yeah,
in a
that's
folder?
a Great question. So I do think that you can take a screenshot. So let's take a step back. We have companies that are having problems where either the managers that are doing, they're supposed to be doing the I-9s don't have the ability to print out, or the employees don't have the ability to print out. So in some circumstances, we have centralized people FedExing original documents, or mailing original documents out to people. Our office has mailed documents out. So just for the I-9 itself, you didn't ask about that, but that's also been a problem, so I'll throw that out there. So for the copies, I would suggest that you keep it remotely, and then when you print everything else, in other words, if someone mails you a hard copy of the I-9, when you print everything else out, you'll be able to print it, or if it's already uploaded to an electronic system, that's okay. But if you're paper, you're paper. So at the end of the day, everything will have to be printed and saved via paper. Does that answer your question?
It does. So if I am paper, I don't have an electronic system. Maybe and I'm emailing the form I-9 that I can find on the USCIS website to my associate, and they're completing Section 1 and then sending it to me by email. That's not enough. You're telling me I have to actually print that out, or have it printed out and signed in original ink and sent over to me for me to comply, even in this remote scenario?
Yeah, and I don't know about sending it over. That's some of the struggles that we're having, and we're really doing it on a company by company and sometimes site by site or location by location basis. I have different companies making different decisions. Some of them are telling people to hold on to Section 1 of their I-9, and when they physically come back, they can bring it in with them. Others have a centralized place. I have one company that's actually sending them to us. And it's just a small number, and we're collecting the originals here. So that's something I would say that you're going to have to think about, and then that'll be part of your policy. But I am saying that.
Sorry, yeah. So I think what we've experienced from a lot of our clients is just logistically trying to figure this out. Even though this remote option is supposed to help us, it also opens up a lot of questions. So, as Dawn mentioned, you're really going to have to think about it. And I think it's really important to identify what will be logistically your policy, and then apply that across the board, and make sure that you're implementing some of these things, like noting that it's a COVID-19 remote completion, making sure that you pull together your documentation that shows that you will work from home, and making those notations, because the point is to make sure that you're ready in case of an audit in the future, which we anticipate happening, that you have all of this documented.
That's right. So once you do complete the I-9, if you're the HR, you do want to, what we're telling our clients is to put COVID-19 completed virtually or remotely, depending upon, which way, what you want to call it. I would even suggest that you're very clear. If you've completed it by fax or does anyone even still have a fax machine? I don't know. But if you're doing it by email, I would also put that down, because, there are things when you're signing that attestation, and I have it on another slide, you're saying that, to the best of your knowledge, you've looked at the documents, and you're supposed to be looking at the person. I don't know how you can do that via email or fax. So I'm not recommending email. I haven't found one company that's had to use email or fax as opposed to the online, because part of this is looking at the person and then looking at the documents. But that said, at the end of the day, I think ICE is going to be reasonable, and I think everything is really going to start from once people get back to work. So with the virtual, just in terms of the logistics, the other thing that I'm really not happy with in terms of what we got from the virtual is not only does it have to be done virtually, or can it be done virtually, and you have to be fully remote. Once normal operations begin, then you have to do it a second time. So it's a two-touch. And so for companies that have had, or that are in the process of hiring surges, this is going to be a nightmare. And you may want to think twice about whether or not you should be using it. And if you're using this, you may want to think about whether or not you want to switch to another option. But when you do come back in, the person that is reviewing, the in-person verifier, should be writing COVID-19 completed virtually or remotely, and then enter the information into Section 2 at that point. Now, what we're also suggesting, again, is saying how you've actually looked at the documents. The second, annotation, when you are coming back, the person that's looking at them, the government's asking you to say, who examined it. So we're saying, as a suggestion, documents physically examined by, Jane Smith on whatever date she actually goes ahead and looks at them. And that's, I think, something that, a lot of companies are not totally thinking through. I don't think that the government thought it through. We've had so many questions that we've posed to them. What happens when? And by the way, let's take a look at this slide. There's two. I posted the ICE guidance. In other words, what was in the ICE press release that Angela mentioned when they physically extended it. Or what the CIS, what they posted in their Q&A. So in the ICE guidance, it says, add documents physically examined with the date of inspection to the Section 2 additional information field on the Form I-9 or in Section 3, because you can also do virtual re-verifications. But CIS says Section 2 should be completed by physically examining both the employee and the work authorization documents. Whoever does this should sign Section 2. So wait a minute, was Section 2 already signed, or are they telling you to sign it now? I think it makes sense that the person who's physically looking at the documents needs to sign it, but I do think that the first person should also have signed it if they can. If you look at the certification up there, you're saying that you've attested under penalty of perjury that you examined the documents presented by the above employee and that they appear to be genuine. Again, you have to feel comfortable signing that certification. So what we're advising our companies is, in addition, whoever looks at the physical or the initial virtual documents, sign Section 2. If you look at it again, if you're the same person, if you're the person that's looking at the second set, the in-person documents, go ahead and just make the annotation that we spoke about. But if you are the person, if you're not the same person, right? If there's a new completer, you're the person now that they are that they're visiting when they come in. You're not the first person. You may just want to record the documents, even if they're same, on another Section 2. Now, some of the electronic I-9 providers are already building this out, and some of the better providers are building out a process whereby you'll be able to either reattest to what you're seeing if it's the same, or change the documents if it's a different one, a different set of documents or a different document. And then when you sign it, you'll actually have an attestation that you're signing. So that's interesting, right? So even though it may not print out on the document, there will be an attestation behind the scenes, and it will be available to the government via an audit trail. So these are all things that you want to think about, especially if you're in a high-risk industry where individuals, where there may be some risk of fraud or anything else like that. So I think it's important to kind of think about what your options are and anticipate that we may get some additional clarification or guidance from the government that we have not yet seen. So we're erring on the side of caution, and we're asking everyone to be particularly careful about this. Now,
so
we covered some of
this is great. They kind of gave us a little bit of leeway with virtual, which they never have before. They kind of haven't moved on with the times as things like FaceTime and Zoom and whatnot has become available. But with that said, I have clients who are opening offices maybe staggered, maybe some are opening, some are not. They're kind of all over the place. It also depends on what the state requires. Are there, safer at home, shelter in place in California versus what's happening in Georgia or Texas or wherever. So with all of that and this idea that now I have to I-9 people twice, that's a lot of work. What other suggestions do we have for our clients who really don't want to necessarily keep track of all these logistics and figure out which office is opening when does my 3 days start? How am I staying compliant if I get virtual? What are my options?
Yeah, so my favorite option is the authorized representative. It's basically a process whereby a company designates a third party to complete the I-9 on their behalf. Basically, the third party is stepping into their shoes. They're able to sign. They're able to view the documents on behalf of the employer. Now, pre-COVID, we used this. We had a lot of employees that work remotely. There's actually a business, where you had third parties that offered I-9 services. Some of the vendors associated, the I-9 vendors associated. So this is nothing new. What's new is the way we're rolling out these policies and who we're allowing. So obviously, you can't go to a lawyer or a notary or another professional or a manager of another company to do the I-9 during COVID. Who are you going to use? You're going to use your friends and family because that's who you're sheltering with. So at this point, we're writing policies that allow for that third party to be someone that is close to you, that you're not going to endanger yourself or anyone else. When you're putting a friends and family policy together, there's a lot of things to think about. You have to, first of all, realize that, again, this is nothing new. The regulations have always allowed for a third party, but that third party, if the third party does something wrong or doesn't accept a document or discriminates against the individual, you could be held responsible for that. And as a matter of fact, in the new Form I-9, the government reminded us about that. In this situation, it's doubtful that the friend or family will make things difficult. They may make things too easy. So you have to have parameters in place. You are going to need to develop a set of documents that you're giving to the employee. You're going to explain to them what they're doing, what their responsibility is. You're going to explain to them the timeline. You're going to give them instructions to give to whoever the person is that are completing the I-9. Some of our companies actually want the designation before. They want you to email and tell the company who's going to be doing the I-9. Some don't. Some just have a form to fill out that says who you are. When you're giving you're asking somebody to do it, you're going to include a sample I-9. You're going to give them some basic instructions. Some of our companies are giving out the M274. I know everyone has a lot of time on their hands, but I don't think anyone's reading an M274 before they do the I-9 for their sister-in-law or their husband or their parent or child. I think a nice little cheat sheet that explains, here's the list of documents, here's what you need to record, here's how you're going to record it, and most importantly, here's the phone number to call if you have a problem. So that's one way, to take care of this. Allow for individuals that that can be available. If you're going to use this policy, Massa, like you said, there's, the first one's not perfect. You have to think that this one's not perfect either. I think it's important if you're going to use this policy, the virtual policy mandates that you take document copies. I would not write an authorized representative policy today without mandating that document copies of the identity and the work authorization, meaning the A or the B and C documents, be copied, okay? I would also be careful. Normally, when we write authorized representative policies, and it's a third party that's not, close to the employee, we make sure that that third party doesn't keep document copies on their phone or take a picture. We never want them to be the ones to send the company in the document. We can write it in such a way to make sure that the PII is safeguarded. So it is definitely important that these are all things to think about. The most critical concern, aside from managing, your PII and making sure that you're working with your electronic vendor, because different vendors have different processes, is making sure that you're going to have a strong secondary review in place. You can't do this authorized representative policy without having a team of HRs reviewing the I-9s once they come back to you. We'd like to do it as real time as possible. So there's if you have people sitting at home, we can set up policies where we have data rooms or, secure sites that these I-9s can be uploaded to. I'm not a particular fan of having I-9s and personal information emailed. There's a lot of things that can be done. Just like the virtual policy, you have to track, who's doing the I-9, when is it being done? And then the timeline. especially if you're E-Verify. So either way, you need to make sure that you're doing the I-9 timely, Section 1 on day 1, Section 2 by the 3rd day of employment. If you start on a Monday, by Thursday. If you're E-Verify, you're going to have to do E-Verify by that Thursday if they're hired on a Monday. Well, how are you going to do it if the person, like you said, Masa, if they're sitting with the I-9s at home? If your HR has access to E-Verify, they can work off the documents that they have, the copies that they have. If they don't, they're going to have to get these documents to them timely. Does that make sense in terms of a timeline and responsibility? Any questions? I'm trying to watch on our
Dawn, this is Angela. I'd just like to comment on a couple of points, if I could quickly.
Absolutely.
Obviously, employers recognize that if you're dealing with friends and family who are co-located in quarantined or sequestered housing, that the source of income of the person being verified might be relied upon by the party who's serving as the authorized representative. So there's got to be a recognition, if there is an assumption of liability for the authorized representative's mistakes, that there may be some misbehavior, some temptation to fudge employment eligibility verification procedures. Secondly, this concept of document copies presents a real conundrum if the employer does not generally copy documents, as is their option. I think we're all torn with the idea of having inconsistencies in document retention of copies because in some instances copies are not kept. In other instances, such as authorized representative or virtual I-9 during COVID, copies are essentially required to make sure the process works in compliance with what is expected. So I just thought I would throw that out there, and I'd welcome your comment on copies and or on the trustworthiness of the authorized representative.
Yeah, absolutely. And I wish we had more time. That could be a subject of an entire webinar. I agree with you. And that's why and we're going to talk about fraud docs in a minute. That's why I think it is important to have that secondary review. So the copies are generally good enough that you should be able to, again, mandate back in front of the copies, take a look at them, and, make sure that there is no fraud. Look, at the end of the day, in terms of the authorized representative, you won't have that secondary look when the person comes in. So a lot of our companies, if they're using authorized representatives for COVID, they are thinking about how they're going to interweave the badging. Some people do come in and you get your key card or your badge, whatever it is. They are going to be considering a second look there to make sure that the person who completed the I-9, right, is actually the person that's physically in front of them. I don't think that we're going to see a lot of nefarious individuals that are, trying to game the system in this way, but it's possible. So, badging is a way to keep it on the back end to take a look when the individuals come in. In terms of copies, I know my partners on the phone all know that I'm a huge advocate of mandating copies. I've been doing this since the early 90s, and I've done a lot of investigations. I've never had a situation where having document copies has hurt my client. I didn't always recommend, especially because I worked in industries that had, high fraud, and maybe the quality of the copies, may have been problematic. But over time, they've helped our clients. If you have a copy, your exposure, your violations, in terms of fines and penalties will generally go down, because if you make a mistake and you don't have a copy, in many cases you'll have an expensive substantive violation as opposed to what we call a technical violation, where you'll have an opportunity to correct it because you've maintained a copy. So that's a subject for another webinar, but I am a big advocate. So, we're seeing a lot of questions on, well, if you have a lot of individuals, how are you going to use virtual and, come back and then I-9 thousands of employees in 3 days? I think it's a problem, and I think you're not going to be able to. And I think that's why you have to look at the authorized representative reality. And that's where a lot of our clients, had ended up. The other thing to look at is the regular I-9 completion. So again, maybe you don't have HR in sight, but you're looking at options 2 or 3. Should I use an authorized representative, or should I try to do regular I-9 completion? Either because we're business as usual or because there is someone there, a shift manager or something that can do this. Look, at the end of the day, we're just seeing, we're going to continue to see a shift in the way we do business. These are the things that we have to advocate, and we are going to have to continue our dialogue, with the agencies to make sure that, we're asking for things like remote, and we're asking, real remote, real virtual, where we don't have to come back and redo it again. I mean, there's no perfect option, so you really have to think about what is best for your situation. Leon, did you want to take a minute just to talk about our policy and how we're working together with many of our companies on dialogues with the agency and as well as with Congress?
Yeah, no, absolutely. So one of the things that we've been hearing from a number of our clients is that in many ways they like the new flexibilities that they're seeing in the context of the COVID epidemic, and that in fact they would like them to become more permanent. And that's something that Dawn, as you know, has been under discussion, in the among the I-9 people, the enforcement people, for a number of years, and for a variety of reasons. There's always been a reluctance, really, because of a lack of confidence in the ability to verify documents remotely. There's always been a reluctance to cross that line, but now there really is some interest in among the business community to really push forward with the government to create, make at least some aspects of this flexibility more permanent and more durable, or maybe really just change the way it's done altogether to allow for better remote verification. And so a number of companies have expressed an interest in coming together to advocate together for changes in how this is done in the future, and that's something that for a lot of you on this call who represent companies for whom this flexibility might be very important. There's really an opportunity for you here to sort of join that group of companies for flexibilities as far as remote verification, but also flexibilities in other ways. So this is something that you really will all want to think about.
Yep. Yeah, it's a great opportunity. I mean, I've been, I think when Randy Johnson first came to Seyfarth, it was one of the first things I talked to him about. Let's put together a coalition of employers and let's take remote because look, at the end of the day, the regulations still refer to keeping your I-9s on microfiche. I mean, and now we're talking about faxing. The government has to catch up with industry, and I think that this is our opportunity. Everything is being redone, and everything is, we're scrambling, right? We are just putting together very different things as a result of the COVID-19 pandemic, and time-worn and reliable processes and procedures are going to have to be relooked, not only by employers, but by the government. So, fortunately, we have a continuing ongoing dialogue with them, and to the extent that there's the ability for them to move the needle, I do believe that they will partner and they will work. So let's talk about I'm going to get through some things quickly because we have so many questions. Talk about hiring surges and just plain, hiring concerns. So for certain industries, we're seeing a huge number, right, of people coming in. What we're also seeing is shift in the workforces, especially in hospitality. Our restaurants have been so hard hit. Our hotels, travel. I mean, you all know, right? Especially if you sit in this industry. I mean, I'm on the phone with so many of you on a day-to-day basis. What are we doing with furloughs and layoffs and terminations, and how do we handle Moss is dealing with the visa implications and the compliance on that side. And, what do we do when we're bringing people back to work? So the reality is we're going to have individuals that have been in jobs for a really long time. Many of them were hired before the Immigration Reform and Control Act of 1986, before there was such a thing as an I-9. They've been working, they've been loyal employees for that long, and now they're being let go. And some of them are trying to work for other companies. Unfortunately, individuals like that, and then others that have I-9s, but maybe not with legitimate papers, are now moving to other companies. So it is important to be vigilant, to be compliant, and to make sure that when you are looking at new hires, that you have processes in place to be able to review the I-9s and make sure that that you understand kind of what the backdrop is. What we're hearing from many of our companies is that if they use E-Verify, which is the government's online system to verify the work eligibility, they have a much higher inconsistency, a notice of what we call the tentative non-confirmations, where the government says, hey, there may be something wrong, not definitely something wrong, but we need to have the employee, give us a call, either the Social Security Administration or the Department of Homeland Security, and we're going to have to dig into this a little bit. I believe we're seeing a much higher number of the TNCs because people are shifting jobs, and unfortunately, they are not authorized. I mean, at the end of the day, we need comprehensive immigration reform. We need to legalize the status of these individuals, so many of them essential workers. Again, another topic for a webinar, a much bigger topic than a webinar, actually. So when we're returning to work, again, there's so many things. You're going to have a checklist. We're working with our companies to make sure that you have your processes in place. Did you use virtual remote? Did you use the friends and family or the authorized representative? Someone has to be tracking this. Someone has to own it. There has to be that review when you are returning to work. Now, the good news is ICE has said in their statement right from the beginning, any audits, any notices of inspection that they do, they're going to use that in-person completion date as the starting point. All right. So it's not going to be a look back. They're not going to look at whether or not you were, probably they're not even going to look at whether or not you completed the initial I-9, timely. I'm not saying don't complete it timely because they told you should, but this is the date that they're going to be looking at, 2 years from now or 3 years from now. So it is important. There is no one size fits all policy. Every day I get a call. Can you just send me over your policy? Yeah, of course, we have a template. We don't reinvent the wheel every time we do this. But you use this electronic I-9 system, or you keep your paper I-9 central, or you don't have enough people to do X, Y, and Z. There are nuances in this process, and they have to be worked out, because if you just put a policy together and you don't think about the logistics, you will fail and you will have problems on the back end. So it is critical to make sure that you understand how you're doing it now, right? That's one thing. It's hard for me to work with the person who doesn't understand how they're doing it now. I have to get to the level of the individual that's dealing with it, and then how you're going to do it in the future. So these are all things that we need to make sure that are tracked. We know that people, even if you're a trained HR professional, and this is what you do for a living, you're rushing now, you're stressed. Maybe you did a virtual, maybe you're the person doing a virtual. When you have, that 8-month old baby crying in the background, or your 16-year-old, is saying, hey, Ma, I need to get on Skype right now. You got to get off. You're probably not paying that much attention, or the level of attention that you would be able to have at your workplace. So keep that in mind. Build in that secondary level of review, and it will, I promise, serve you well. Have a fraud doc training. I don't know. I'm throwing up these things. I found these particular cards at least 2 of my companies over the years. I think these have shown up. The one on the left, it wasn't even the same. Didn't even look like the guy who presented it. Reasonable person standard. These are fake cards. Okay, so make sure that you spend the time in providing a fraud doc training. It's the reasonable person standard, right? You just have to make sure that your people know that the documents have to appear reasonable. You don't have to be a document expert, okay? They just have to appear reasonable on their face. You're not a document policeman. You don't have to have a white light and being like a bouncer at a club, but you should know what a green card looks like, all right? These are older versions of the real green card. These are real, by the way. And here's a newer version of a green card. The same thing like a driver's license. If you live in the state of Virginia and you have a Virginia driver's license and all your people are from Virginia, you should have an idea of what a Virginia driver's license looks like. You may not know what a California driver's license looks like, but if the font is falling off the page and the picture looks like it's pasted in, then it's not reasonable on their face. Okay, I'm going to take a break as we go to the other section. Leon, do you want to go through the code? Oop. I'll do it. So it's Seyfarth Shaw, SS, like Seyfarth Shaw, SS 4479. So SS, as in Seyfarth Shaw, 4479. Leon, you want to talk to us about other changes in the policies?
Very much do. Want to talk about some additional flexibilities. I should share, Dawn, that we probably have the record number of questions that we've ever had in one of these webinars, which I think reflects how important this issue is and how much confusion there is among employers. So I think this is great that we have the opportunity to talk about this today. I want to point out some flexibilities with respect to different sorts of expired documents that may be presented to you by an employee. As you all know, ordinarily, most of the documents that you would be inspecting during the course of an I-9 verification need to be current documents. They cannot be, in most instances, they cannot be expired documents. Recognizing that, in fact, a lot of different governmental agencies, driver's license bureaus, various federal agencies, are closed, and not to mention that a lot of people are in shelter-in-place mode, USCIS has authorized a number of flexibilities in order to accept expired documents. So the most significant of these relates to driver's licenses, and USCIS has now said, as of April 3rd, that in a state where the expiration date of a document has been extended as a result of COVID-19, and usually this will be up on the driver's license agency's website, then that is an acceptable List B document. So when you've accepted such a document, you need to enter the document's expiration date in Section 2. You have an example here. You need to enter all the ordinary information that you would enter. And then in the additional information box, which will be right under that List A, List B, List C blanks that you have there, you need to enter the words COVID-19 extension, and that, of course, supplies the reason why you would, in that instance, be using an expired document. Now, on May 1st, 2020, just a couple weeks ago, USCIS expanded and in certain ways actually relaxed that policy. So more broadly, any List B documents, so those are those identity documents that are set to expire on or after March 1st, 2020, will be acceptable, including those that have not been formally extended by the state's issuing authority. Now, what's the difference? Now you no longer have to have an actual extension from the state of the expiration date. So now you can treat, in this new instance, you can treat any List B valid receipt as an acceptable document. Now, what's going to happen then is that the I-9 will need to be updated within 90 days after the termination date of the temporary List B policy. Now, you may ask yourself, when is the expiration, when does the policy end? That hasn't been established yet. That's basically tracking the course of the national emergency. So you need to stay tuned, or at least rely on us to stay tuned and inform you about when USCIS, in fact, establishes a termination date for the temporary List B policy.
Yeah, and I was just going to add to that. So that's, that is a really big thorn in my side for a lot of our clients. Many of our clients are just too big to track, and many of our clients are too small to track, right? We don't have the resources, because what they're basically saying here is you have to treat, if your state did not extend the validity of the document, so in most cases it'll be a driver's license or a government ID. If they're not automatically extended, if they are automatically extended, you're good, you're done. Right? You record it, you run E-Verify. Well, you can run E-Verify both, but you have to run it both ways. But you don't have to do anything. But what they're saying is, if your state did not extend, oh, and by the way, how do we know if the state extended? So is there a list that the government posted? Nope. They haven't done that either. We're trying to track that for many of our companies. Many of our companies are doing it on their own. So you have to track whether or not your state extended. And if you didn't extend, you're treating it like a receipt. So when we say receipt, we say receipt like a replacement receipt for the I-9s. And in that case, it's usually a 90-day window. Well, how do you know when that 90 days start? So we've gone to the government and we've said, hey, can you give us like a date? Can it be the same date for everyone? Can we push it out like to the end of the year and then have 90 days from then? Because otherwise we have to know when people are coming back to work, and it's going to be very hard. So we do have to stay tuned on that. Sorry, Leon, go ahead. It's a pet peeve of mine. So
no, agree. I think that's a very critical guidance. So again, the same as in the driver's license context before. You'll record the document information under List B. You will record the now expired expiration date. And then you also want to make sure to enter COVID-19 in the additional information field as the explanation for why you're using an expired document. Also want to mention that E-Verify, you can use those expired documents to create an E-Verify case for an individual. So that's another flexibility that's now been extended. There are other E-Verify related flexibilities. The time to extend tentative non-confirmation has been extended. You still need to have reviewed the documents within 3 days with a remote hire date. That requirement does not change. But now the employee has a longer time to resolve the tentative non-confirmation. And that means that you can't, for the reason of not having resolved that TNC, terminate that individual during this extended period. And with that, we've hit the end of our presentation, and we'll open up for, we'll be starting to answer some of your questions. Dawn, I think I'm going to hand it back to you.
Okay. All right. Wonderful. First of all, are we going to take any telephone questions? We have enough here, but if not, we can open up. Otherwise, I'll just start with the individual.
Yeah, we have no instructions for taking any dial-in questions.
That's fine. We have plenty.
Exactly.
That's fine.
Exactly.
Okay. All right. So one of our questions, can an authorized representative be a member of the family since some individuals are sheltering in place? And so, yes, absolutely, the individual can be a member of the family. It's really up to the company. You're allowing a third party to step into your shoes. So, again, if you have a strong secondary process, I think it's fine. And frankly, it's going to be a member of the family, or it's going to be a roommate or somebody that you're close with. I would assume if you are sheltering in place. So absolutely, it can be. Does anyone else want to take? Otherwise, we can kind of do a round robin. Otherwise, I'll keep going. I'll keep going in the meantime. So how likely is the virtual approval process going to be extended beyond June 19th? Look, I think it's going to matter where we are as a country. I think that the government will continue to evaluate based on, where things are and whether or not we're still in a national state of emergency. I think, frankly speaking, we're going to have a situation where we have companies that are coming back, even within the same company. It's going to be a rolling return to work. So the government's going to have to understand that. They're going to have to realize that, and we are going to, we're going to have to kind of make it up as it happens. So we'll see. We'll see where everything is. I hope we're in a place, God willing, that we'll be able to. To return back in June.
Could I jump in on a question here? It says, are I-9s required when you bring back a furloughed employee? And there the M274 and the USCIS I-9 regulations say a temporary layoff due to lack of work does not require the preparation of a new I-9 because it's not treated as a new hire as long as there is a reasonable expectation on the part of the employer and the employee of continued employment. And in a furlough, that would ordinarily be the case.
That's right. And I think the only thing you need to be careful there, and we're getting some questions from many of our clients where, if it's a temporary furlough, that's one thing, but if there's been a termination with the expectation that they'll be brought back, you want to kind of look at this to see, kind of what you're telling one agency. I know for certain benefits, individuals are being, fully termed, and for others, it's a temporary furlough. So just make sure that you're kind of not, that there's no inconsistencies as a company.
And there are facts and circumstances that are outlined in the M274 under that section that you can analyze and apply to your situation.
Yep, that's exactly right. That's a great place to look. The new M274.
There's a lot, logistically with the remote completion due to COVID-19 that we have several questions that kind of hit on the point of when does that 3-day completion requirement start as we bring people back in? Let's say we do have a phased-in approach, some offices, some not open. But not only that, if we have a phased-in approach and the employee has the option of coming in or not coming in and continuing work from home even though we're open, do we still require them to come back in? So there's several of those kind of hitting on those logistics if you're taking advantage of the remote completion. And really, it is very fact-specific in terms of what you can do or what your logistics will look like as you open back up. Dawn, Leon, any thoughts on that 3-day count for employees once offices open back up?
I think memorializing the policy and making sure that you are, if you do have those options, and that's what I mean by tracking it. So making sure that you know what the global policy is and then what the particular reality was for a particular individual. I think ICE is going to have to be, you're going to have to give us discretion here. I cannot imagine that if a company or a state or whatever, an agency is going to allow for somebody to work from home, that you're going to be able to, force them to come in. So in those kind of cases, you may have to fall back on the authorized representative. If there's a situation where somebody is sheltering in place alone, I would take an affidavit, say, hey, person's been alone. This is the affidavit. They've sent us this email. We've tried. I think it's going to be it's going to be reasonable. The other thing I want to talk about is virtual interns. We have a lot of companies that are doing virtual interns this summer. Some of them are hoping to come in and bring the students in, by the end. Some of them know that they are not ever going to be coming in. In that case, I would say to you, consider the virtual. The friends and family, rather than trying to scramble at the end to try to bring these kids in. Because again, if there's a reason you're keeping them out, even if the office is open, it may be a good idea to continue to social distance and keep as many people out of the physical workspace as possible. So we have a question on the E-Verify I want to take. Today we received an SSTNC, a tentative non-confirmation with E-Verify. I know that E-Verify extended the amount of time that the employee has to resolve, but what is required regarding signatures on the TNC itself? So some of the more solid electronic I-9 systems have virtual, they've had this before, they have the ability to do the TNC process virtually. If you're paper, I would say put together an email. So you can get the scans, right? You can send them the TNC by email, have them scan, even if you have to take a picture. Most people will have a phone that they could take a photo on and upload it back somewhere. I would, again, you should document some sort of policy. And if you find yourself in a situation where it's impossible to get this to the employee for whatever reason, call the 800 number from E-Verify, get yourself some advice from the lovely individuals that answer the calls, and then mark it on the I-9 with the E-Verify.
Dawn, one other thing I would add is that I would probably make reference to the USCIS special instruction on allowing copies of wet ink signatures. Although that was intended for the submission of petitions, it would be, I think, persuasive evidence to ICE or to the E-Verify verification division if there was ever a challenge that this was the best you could do under the circumstances.
That's a great idea. Why not? I think it's fine. And look, E-Verify is always allowed for the signatures to go back, to sign things via a fax or a scan. So I think it's fine. So reviewing documents virtually, is the employee able to sign the form electronically? If so, how does the process work? So unless you have an electronic system, this is the time I can get on my soapbox about electronic I-9s. They are all not created equal. They are all not compliant with the electronic I-9 regulations. Many companies have gone to electronic I-9s without doing their due diligence on the system, maybe because they're part of a broader payroll or HRIS system. There are electronic I-9 regulations that were actually finalized in 2010. The government has not been very focused on the enforcement of them, but they started to be before COVID. I don't know if they're going to get back to it or not. But if you use an electronic I-9 system, make sure it's compliant. And if you do, then you will be able to sign your documents electronically. If not, you probably are not able to sign your documents electronically unless you meet the electronic signature portion of the regulations. And then you also have to move to the storage. So it's a very complex question, but generally speaking, it's going to be hard to do that unless you're using either a homegrown system, which again, very hard to do and not recommended, or one that's tried and tested in the electronic I-9 space.
And Dawn, just to remind folks, the most important aspect of the electronic compliance with the regulation is the audit trail and the index.
That's
and
right.
ICE has historically said that if there is not an adequate audit trail or index, then they will treat it as having no I-9s, which is at the highest level of fines.
Huge. It is huge. That's exactly right. And they were starting to focus on this beforehand. Maybe they'll get back to it, maybe not. It's low-hanging fruit for them. It's so easy to go in and find a problem with electronic I-9 system and then deem every I-9 created by it to be not created. Someone asked if I said not to delete over documentation from electronic I-9s. Well, a couple things there. We didn't talk about over-documentation at all, but what I did say is that once you've taken a copy, it becomes part of the I-9 pursuant to the regulations, and you should not delete anything that you've that you've taken as part of the I-9. Now, in an electronic situation, if you've accidentally uploaded something that doesn't belong, you uploaded, I don't know, something personal, whatever, certainly I think you can remove it. But if it was taken, even if it was over documentation, it should remain with the I-9. You can go back as part of an audit and, put training over documentation and note it. But I do not personally believe that you should be removing anything from the I-9. I don't know if anyone else has any.
Well, I would say that it's not absolute evidence of over-documentation. It may be that the employee tendered more documents than minimally required and that the authorized rep accepted everything that was given, but not specified at the request of the employer that those certain documents were required. So I would probably do a memorandum to file.
Yeah, that's a good idea. You can certainly note it. So you just want to be careful. That's probably a lot to think about. But yeah, I wouldn't disagree with that. So look, we have a lot of questions, and I think we are at time. If anybody would like to put some closing comments in, then we will wrap up. And we promise that we'll, if they're not legal questions, we'll try to get back to each of you. And for those Seyfarth clients, please do call your relationship partners so that we can go through this. Closing comments?
Yeah,
I think that. Go ahead, Leon.
Yeah, no, I mean, I think to put it all into a box here is, ICE is not going to stop being an enforcement agency just because there was a COVID epidemic. There are these flexibilities. They have very clear instructions. And I think we have to assume that ICE will insist on observance of those instructions in the event of inspections down the line. So I think a lot of what you heard today is how to do this in accordance with ICE's expectations, and reasonably in accordance with your business realities. But the thing to keep in mind is that the risk associated with this area is not going to cease to exist, so it is going to be important to be careful.
I would add that this may be an opportunity for employer advocacy to your members of Congress and to the White House to say that this pandemic has shed a light on the inability to document individuals in a way that is meaningful. It's revealed a large undocumented population that has all the more need for comprehensive immigration reform.
Masa, anything on your end? Maybe we lost her. All right. Well, I want to thank everyone for joining us. This is a really dense and complex subject. Those of you who know me know I live and breathe it. But we are working very hard here over at Seyfarth to break it down for you, to make it easier for you. And I agree with both Leon and Angelo. Now is the time from a policy perspective to move these things forward. It will take time, and it does take time. These are not, one-size-fits-all policies that you can implement. You do need to think about it. And I do think that the government is going to be reasonable. I think that Immigration and Customs Enforcement, Homeland Security Investigation, HSI, I think down the road, if you document and you memorialize and you remember you're not going to be here possibly 3 years from now, put everything down, help your company, do your best, and, let's just try to get through this. I hope everybody stays healthy and safe, and thank you for joining us today. That'll conclude our webinar. Thank you.